is 10 o'clock and I like starting things on time because I know time is precious and we all have a weekend to get to. But most of you know me, I'm Larry Gonzales with Align Mortgage. And as most of you know, at Align Mortgage, we educate veterans on their VA home loan benefit and take great pride in that. But one of the other things that is missed, I think, often is what do you do after you become a homeowner, right? You get homeowners insurance, you have life insurance, but how do you really protect that home you bought? And I had the opportunity to work with Dean Park. Dean Park is an estate planning attorney, over 15 years of experience. He's my estate planning attorney. And I was so impressed with how he explained the process to me and explained why it was important to protect your asset and that tenants by entirety wasn't enough in case of extreme issues where loss of life and whatnot. I wanted him to share his knowledge and his insights with my clients and really take our education at Align Mortgage to another level. So really, I'm going to turn this over to Dean right now. If you do have questions throughout the webinar, please go ahead and use the Q&A box, and we'll probably answer them at the end because I think during the process we'll answer most of those questions. But go ahead, ask them. I'm going to keep tab of them, and we'll do a short Q&A period when we're done. All right. I hope you guys enjoy this. And without further ado, Dean Park, take it away.
Thank you so much, Larry. Thank you so much for putting this event on, and thank you, Align Mortgage, for coordinating everything. Thank you, everyone out there, for taking the time out of your busy schedule to come today to learn about this topic, important topic that we call estate planning. Now, we're going to go through a lot of information today. So with a limited time, let's jump right into it, okay? So the way that I want to explain this estate planning today is I'm going to first explain to you what's going to happen if you don't do any estate planning. The reason why we want to go there first is because if you understand what's going to happen if you don't do the planning, it's going to make you understand and appreciate why getting this planning is so important. Before we do that, however, I do want to go over some basic terminology you're going to hear me repeat throughout this presentation. Now, that first term you're going to hear me repeat is this thing called a probate proceeding, which is a court proceeding. When you die, the personal representative or the court will appoint someone called a personal representative to administer your estate, to manage everything and get it to whoever it's supposed to go to. The average cost for a probate proceeding is probably $6,000 to $8,000. That's for a simple probate. It's not uncommon for probates to cost more, okay? Another term you're going to hear me repeat out throughout this presentation is incapacity. Incapacity basically is the inability for you to make decisions or act for yourself because of some type of mental or physical disability, or because you're under the age of 18, because you're a minor, okay? Another term you're going to hear me repeat is conservatorship proceeding. That is also a court proceeding where the court will appoint someone called a conservator to act on your behalf because you are incapacitated, okay? Now, if you are taking notes, what I would like you to do is next to write out your name, and next to your name, write down $6,000, okay? Below your name, if you are married, write your spouse's name, write another $6,000, which represents the low end of a cost for a probate because everybody's going to die, okay? Below that, if you have any minor children, I want you to write all of their names down, okay? Minor meaning under the age of 18. Next to each child's name, I want you to write $5,000 times the number of years until they will turn 18 years old. So for example, if you have a 15-year-old child, you're going to write 5,000 times 3, because 3 more years they're going to turn 18. And whatever that number is, calculate everything, add all those numbers up. And I would argue that that is the potential cost, financial cost of not getting your estate planning done. And I will also argue that that would be a very conservative number, okay? Because we're not taking a lot of other things into consideration, okay? So just keep that in mind throughout this presentation. So the first thing we want to talk about is what's going to happen if you don't do your estate planning and now you die. Okay, you died without any type of estate planning. What's going to happen is we're going to have to open up this thing called a probate proceeding. Again, a probate is a court proceeding where the court will appoint someone called a personal representative to gather all the things you own, pay off your creditors, pay off your taxes, whatever's left, the personal representative will distribute to whoever the law says it is supposed to go to. Okay. However, there's a lot of drawbacks with that probate proceeding. Some of the main drawbacks is that it is a public proceeding, so that there's a loss of privacy. Anybody, the general public, can go to court, request to see documents filed in this probate so that they can figure out, what you own, who your creditors were, ultimately who got what, if anyone's fighting. All that stuff is open for the general public to see. Okay? Another problem is probates can be very expensive. Again, even a simple probate will probably cost $6,000 to $8,000 to completely administer. It is not uncommon for probates to cost well over that, okay? Especially if you have multiple properties or you have other issues going on. Probates are also very time consuming. So again, even a simple probate will probably take maybe 6 to 8 months to completely administer. That's really, really quick, okay? Average, I would say about a year, but it is not uncommon for probates to stay open for several years. That's actually normal. During this period of time, beneficiaries are waiting to receive whatever they're supposed to be getting. Okay? Another problem is these probates are what we call an invitation to a fight. Okay? And the reason I say this is because before we open up this probate proceeding, we have to give notice to all interested parties. Interested parties includes your immediate family, your extended family, your creditors, and the general public. Okay? And the reason is because we're going to publish this notice in the newspaper. And basically what this notice says is, this is the date and time we're going to open up the probate proceeding. If you have any reason to object, this is your opportunity to come to court and voice your objection. Okay? So invitation to a fight. Another problem is you lose control because you don't get to decide who that personal representative is going to be. The judge is going to decide for you. Okay? You don't get to decide who's going to get your things. The law will decide for you. Okay? Now, in a typical family situation where we have husband and wife, joint children, a lot of times what the law says is probably what the clients want, which is when one person dies, goes to spouse, when spouse dies, goes equally to the joint children. Okay? But we do have to go through a probate to accomplish that. Okay? However, if you have what is called a blended family situation, meaning either husband and wife has children from a previous relationship, a lot of times what the law says is probably not what the clients would have wanted, and it's going to cause a lot of problems. I'll give you a quick example. Okay, in this example, let's say we have husband and wife. Husband has kids from a previous relationship, and when husband died, his estate consisted of $1 million, just to keep the math very simple. Okay, so what the law says is when husband died, the first 100,000 of that million will go to the surviving spouse. Anything above that first 100,000, which is 900,000, half of that, 450,000, will also go to the surviving spouse. But the other $450,000 will go to his kids from his previous relationship. Okay? Now you can see that's going to cause a lot of problems. Probably what's going to happen is the biggest asset in the estate is the house, okay, that was in husband's estate that wife is still living in right now. Okay. And wife, chances are, doesn't have $450,000 just laying around to pay off those kids from the previous relationship. So what's going to happen? We're going to have to kick her out of the house so we can sell the property, so we can generate the money to satisfy those children from the previous relationship. As you can see, that would cause a huge problem. Unfortunately, if you don't take the time to do your planning, the law tries its best to do what it thinks you may have wanted. But unfortunately, in a blended family situation, that's very difficult to do. Okay. Another problem is ultimately when the personal representative is now in a position to start making the distributions, because they already paid the creditors, they already paid the taxes, so now they can start distributing the assets to whoever it's supposed to go to. That distribution is going to be what is called an outright distribution, meaning it becomes that person's property, asset, money at that time. Okay. Now, the reason that is not necessarily good is because you don't know when you're going to die. And you don't know what position your beneficiaries might be in at that time when you die. Okay, so what if when you died, your daughter's going through a divorce, your son's getting sued, your other child owes somebody money. Okay, in a probate situation, we have no option. We have to just give it to them. It is theirs, and possibly it's going to be subject to whatever might be going on in their lives at that time. Okay, so that's what I mean by an outright distribution. Okay? Another problem is what I call babu's beneficiaries. Okay. What I mean by babu's beneficiaries are beneficiaries who are usually younger in age, maybe 18, 19, 20 years old. If you think back when you were 18 years old, if you came into a lot of money, what would you have done with it at that time? Okay. Most of my clients, or I know for a fact, if I was 18, 19, 20, 21, if I came to a lot of money, within a couple of weeks, it would be gone. I would buy a new Ferrari. I would go party with my friends, go traveling around the world, and it will be gone. Okay. So that's another problem. Because it's an outright distribution, it's that person's assets. That person is free to do whatever they want to do. Okay. Also, Babu's beneficiaries could be older beneficiaries. Maybe they have a substance abuse problem. Maybe they have the gambling problem. Maybe they're just not good with money. Again, bottom line, it is an outright distribution. Okay? Related to that is what we call minor beneficiaries. So if you have a beneficiary who is under the age of 18, the law says that that minor is deemed incapacitated due to the fact that he or she is a minor, okay? Which means your personal representative cannot simply take your things and say, here you go to the minor. That is not going to happen. Instead, what will happen is we're going to have to open up another court proceeding in addition to that probate we just had to open up. And that is called a conservatorship proceeding. And as I told you, the purpose is for the court to appoint someone called a conservator to accept the assets from the personal representative to use for the benefit of that minor beneficiary. I already told you the drawbacks, expensive to set up. Not only that, it's an ongoing proceeding. Every single year, the conservator will have to go back to court and account to the court for how he or she used the assets for the benefit of that minor. Every year, it's going to cost a lot of money, take a lot of time, probably $4,000 to $6,000 every single year until that minor turns 18 years old. Okay. Once they turn 18, we have to terminate the conservatorship because they're an adult. Whatever is left, if anything is left, must now be distributed outright to that 18-year-old beneficiary. Now we're back at that Babu's beneficiary problem. Okay. Another thing I want to talk about is this thing that I call the will misconception. So a lot of times clients have this very common misconception that if you have a will, you can avoid this probate proceeding. Okay? I am telling you today that is not true. Even if you have a will, we're still going to have to open up a probate proceeding. The only thing you can really do with the will is you get to say who you want as your personal representative, person in charge, and who the beneficiaries are going to be. But we still have to submit the will to be probated, which means it's still going to be a public proceeding, expensive, time-consuming, invitation to a fight, outright distribution problems, Babu's beneficiary problems, minor beneficiary problems. Okay? So if you really think about it, a will by itself really doesn't do that much for you. Okay? Another thing that you have to understand is a will only takes effect when you die. Okay, so if you are still alive, but let's say you get into a car accident or due to old age, Alzheimer's, dementia, stroke, you are now incapacitated. This will does absolutely nothing for you because again, it only takes effect when you die. You didn't die yet, okay? Which brings us to the next important topic. So equally as important as what's gonna happen when you die is what's going to happen if you don't do your estate planning and now you are incapacitated. Okay? So what's going to happen is if a third party that you are dealing with has any reason to believe that you are incapacitated, that third party will no longer be willing and able to deal with you anymore because of their potential liability of dealing with someone who is incapacitated. Okay, so I'll give you an example. Let's say we have husband and wife. And let's say a husband got hurt on the job, got into an accident, is mentally incapacitated. They own a house together. Wife decides she wants to get a loan on the property, or maybe she wants to sell the property because she wants to generate money for husband's care. What she is going to find out is she is not going to be able to do any of those things. And the reason is because husband is incapacitated. He cannot sign off on that loan or sign off on the sale of the property. Instead, we're going to have to open up a conservatorship proceeding, and the court appointed conservator will be able to transact on behalf of the incapacitated spouse. But the problem I told you was that conservatorship for an adult is going to cost minimum $8,000 just to set it up. It's going to be $4,000 to $6,000 every single year after that until he dies. We terminate the conservatorship. We're going to be right back in the probate proceeding right after that. Okay. Now, a couple of things people always fight about in these conservatorship proceedings. The first thing is whether or not this person is even incapacitated. And the reason is because incapacity is usually not black and white. It's usually very gray, very gradual. You have good days, you have bad days. A lot of times people fight over this issue. In fact, in recent time, that issue has been in the news recently with that Princess Kawananakoa case. They spent, to my knowledge, over $6 million litigating this issue. Is she incapacitated or not? She has her own expert opinions, her doctors, other people have their own experts and doctors, and they all got to go to court. And the judge, who doesn't even know who she really is, will ultimately make that determination whether or not she is incapacitated. Yeah. The other thing people always fight about in these conservatorship proceedings, which is also what they're fighting about in the Princess Kawananakoa case, is the identity of that conservator. Everybody wants to be the conservator because they want access to all the assets. They want to be in charge. Okay. But the bottom line is, if you do not get your estate planning documents done, then these are all the issues that we're going to deal with. And also in recent news, Britney Spears, that's also a conservatorship proceeding that's been in the news that, as you can see, it causes a lot of problems. Okay. So now you know what's going to happen or what the issues are if you don't do your estate planning. Now I want to talk about what estate planning is all about. Okay. So the basic definition of estate planning is, I want to control my things while I'm alive and well. I want to plan for me and my loved ones if I'm determined to be incapacitated. I want to give what I have to who I want, when I want, the way I want. I want to protect my assets from creditors and predators, and I want to accomplish all of this without paying unnecessary estate taxes or having to deal with costly and time-consuming court interventions such as those probates, conservatorships, and guardianships. Okay? So this is what I call the estate planning pyramid. As you can see, the foundation of this pyramid is control. So my ultimate goal for my typical estate planning clients is, I'm trying to provide you guys with as much control as possible. What I mean by that is, while you're alive and well, control to do whatever you want, whenever you want, for whatever reason you want. In the event you are incapacitated, control over how that incapacity is going to be determined. Control over who's going to be in charge to make sure everything is used for your care to avoid the conservatorship. When you die, control over who's going to be in charge of administering your estate. Who are your beneficiaries going to be? How are they going to get your things? Are we just going to give it to them outright, subject to whatever's going on in their lives at that time? Or do you want to take the extra precaution to protect it for them? So it's all about control, but it's also about making sure that you and your loved ones are taken care of and trying to avoid all of these unnecessary court proceedings and expenses. Okay? So what does an estate plan consist of? A complete estate plan consists of these documents, which are the revocable living trust, certificate of trust, pour over will, durable power of attorney, advanced healthcare directive, and the HIPAA authorization. I'm going to go over each one of these documents and explain how each plays a role in your overall plan. Yeah. So the first document is what we call the revocable living trust. What is a trust? A trust is basically an agreement that involves three parties. First party is called the grantor. That is the person who is going to create this trust and set forth the rules, provisions, and guidelines of the trust. Second party is the trustee. That is the person who is responsible to administer this trust pursuant to the rules, provisions, and guidelines that the grantor set forth. Third party is the beneficiary, the person who benefits from this trust. While you are alive and well, you wear all three hats. You are the grantor, you are the trustee, you are the primary beneficiary. You run the whole show. You do whatever you want, whenever you want, for whatever reason you want. So you maintain control. Okay. Now, the key to this trust properly working is this trust has to be properly funded. Okay. So what does that mean? So you should be able to see on your screen a bucket in the middle of the screen. So whenever you think of a trust, think of a trust as a bucket. Okay. On the left-hand side, that's a house that you own. The right-hand side, there's some money there that represents money in the bank, investments, and the insurance, okay? Now, the key to this trust properly working is we need to get all these things into your bucket so that you individually, you don't own those things anymore because everything is owned by your trust. And the process of getting everything into the trust, that is called funding your trust. Very important concept. Okay? Now, the reason that is so important is because as long as everything is properly funded in the trust, we will avoid all those court proceedings. Okay, so upon your incapacity, because everything goes in the trust, we don't need to open up a conservatorship proceeding because the terms of your trust will control and everything is in the trust. When you die, we don't need to open up a probate and suffer all the drawbacks and consequences because everything is in the trust terms of your trust control. Okay. Now, although we can avoid all these court proceedings and other drawbacks, there's a lot more that we can accomplish with the trust. First of all, privacy can be maintained. There's no law that says everybody, the general public, has to be notified of this trust administration. The only people that really have to be notified are going to be the successor trustee that you got to name and whoever these beneficiaries are that you also got to control instead of the law telling you who these people are supposed to be. So also you control everything in terms of who's going to be in charge, who's going to be getting your things, how they're going to be getting it. Okay. Another thing is, even if you have minor beneficiaries, unlike a probate where we would have to open up conservatorship proceedings for every single minors, in the trust, we can put a special provision that says if you have a minor beneficiary, no need to open up that conservatorship proceeding for the minor. Just leave it in the trust, use it from the trust for the benefit of that minor. Another thing we could do is we can provide some creditor protection for your beneficiaries. Okay. So after you die, I told you the drawback of an outright distribution, just giving it to whoever you want to give it to, is you don't know when you're going to die. And you don't know what position that person might be in at that time. Okay? What if they're going through a divorce, getting sued, owe somebody money? If we just give it to them, it might be subject to whatever's going on in their lives. So instead, what we could do with the trust is we would create these mini buckets, so to speak, by leaving things in these mini buckets for the benefit of your beneficiaries. We can serve two purposes. We can protect it against anything going on in their lives at that time. But another purpose of creating these mini buckets is to provide some guidance to your kids. Okay? So for example, if your kid was 18, 19, 20, most of my clients don't want their 18-year-old child to just do whatever they want because they're just not going to be financially mature yet, to make those types of decisions. So instead, you can name somebody in charge of these sub-trusts. So in order for your child to get anything, they would have to ask auntie or uncle so-and-so. Okay? Another thing we do differently than a lot of other firms is with regards to the determination of whether or not you are mentally incapacitated. Remember, I told you that is probably one of the most highly contested issues. Is this person incapacitated or not? Because it's very subjective. Okay? Now, if you didn't have any type of estate planning, it's the judge who doesn't even know who you are that will make this determination. Whenever we're in court, anybody and everybody has an opportunity to argue one way or the other. Okay? If you have a trust, most likely your trust would say, doctor will determine whether or not I'm incapacitated. Okay? Now, the problem with that language is Princess Kawananakoa has a trust and her trust says doctor decides. Her doctor is saying she's fine, she can make whatever decisions she wants. Other doctors are saying she's not fine, she's incapacitated. Okay, so unfortunately, you can get a doctor to say whatever you want that doctor to say. Okay, so in this case, the problem is actually worse because we're still back in court, but now we have competing expert opinions. And like I said, in the Princess Kawananakoa case, I think they spent over $6 million litigating that issue. Okay? So what we do differently is we want to put the control in your hands. In a married couple situation, usually we would say, if my spouse and attending physician determines that I'm incapacitated, that is how incapacity will be determined first and foremost. Because presumably you trust your spouse the most, spouse knows you the best, they will know whether or not you are incapacitated. Now, as a backup to that, if your spouse is unwilling or unable to make this determination, because maybe your spouse is also incapacitated, or maybe your spouse died already, okay? Then we will turn to what we call the disability panel. Today, while you are alive and well, you get to handpick whoever you want, however many people you want. If these people that you handpick determines that you are incapacitated, that is how incapacity will be determined. So I'm putting the control in your hands. You're obviously going to pick the people who you trust the most, who know you the best, who know whether or not you are incapacitated. I feel that's much better than relying on a judge who doesn't even know who you are, allowing anybody and everybody to come in and argue over that issue. Okay? We also can include these things called value promotions. These are provisions to either encourage or discourage certain types of behaviors from your beneficiaries. For example, when my child gets married, give them this special distribution. If they buy their first home, give them this special distribution. Or on the flip side, in order for my child to get anything from the trust, they have to submit to random drug testing. They cannot have been arrested in the past year, things like that. Again, to either encourage or discourage certain types of behaviors. Okay. We also can include this thing called remarriage provisions, and I'll just use myself as an example. So what my trust says is, when I die, my spouse, you can get remarried if you want to get remarried. Unfortunately, we cannot stop people from getting remarried, okay? However, it goes on to say, in order for you to remain a beneficiary under my trust, you have to sign a valid prenuptial agreement with your new spouse with regards to the things in my trust. The reason I have this provision is not because I'm trying to be mean and stop her from getting remarried. It's actually the opposite. When I die, I want to make sure the things in my trust will be used to take care of my surviving spouse, but I do not want it to be used to take care of this new person she's going to marry. In the event they get a divorce, I don't want the things in my trust subject to that divorce proceeding. When my spouse dies, whatever is left, I want to make sure it goes to our kids or the people I wanted, instead of possibly going to that new spouse or that side of the family. Okay? So these are what we call remarriage provisions. Okay? So that's your trust. The next document is what we call the certificate of trust, also known as a short form trust. The purpose of this document is to maintain your privacy. Okay, so what happens is, remember, after we create your trust and think of your trust as a bucket, we now need to get things into the trust. Okay, I would usually assist my clients with getting the property into the trust because most of my clients cannot do that themselves, do a deed. Everything else, money in the bank, investments, insurance, that is my client's responsibility to get it into the trust because it is not possible for me to do it for them. Okay, the bank, for example, if they go to the bank, if I call the bank will not listen to me. They're not going to allow me to put Larry's account into Larry's trust. They're going to tell me Larry has to go in himself and Larry has to request that they move his account into his trust. So when Larry goes to his bank and says, hey, can you move my account into this trust I just created? Most likely the bank will probably say, yeah, we can help you, but we need to see a copy of your trust. Okay. And that trust is kind of a lengthier document. It might be 60 to 80 pages long and has a lot of sensitive information in there. So instead of providing third parties that full copy of your trust, you could provide them this document called a certificate or short form, which contains just the necessary information they need in order to assist you to get things into the trust. For example, the trust name, the date of the trust, the trustee's name, make sure it's properly executed, things like that, instead of seeing the whole trust, okay? So that is your certificate of trust, also known as a short form trust. The next document is what we call the pour over will. Now, this is a very special type of will. It is like a safety net. We hope we never even have to use this will, okay? But I'm gonna give you an example of why we might have to use this will. So in this example, let's say you created this trust today and you properly put everything into the trust so that if you die tomorrow, there should be no probate because everything is in the trust, okay? But instead of dying tomorrow, 10 years later, maybe your parents passed away, and when they passed away, they left you this house, okay? When you got this house, you were supposed to get it into the trust, but you were just so busy or you forgot that you were supposed to get into the trust and you left it in your individual name, okay? And then the very next day you died. Because you died with that property in your individual name, not in your trust bucket, we're gonna have to open up a probate. There's no way around that. That is when this pour over will be submitted for probate. The beneficiary of this will is your trust. So ultimately everything will pour over into the trust so the terms of your trust will control. That is the reason why I call it a safety net. We hope we never have to use this, but it is designed to catch anything we missed or for whatever reason you didn't have time to get into the trust. So that's a pour over will. The next document is what we call the durable power of attorney. This is a document where you get to name agents and successor agents to act on your behalf in the event you are now incapacitated to deal with non-trust matters. Okay? Now, the reason I said non-trust matters is because if you are incapacitated, the successor trustee of your trust already has the authority to manage everything in the trust bucket for your benefit. Not a problem, okay? But again, what if you forgot to put this particular account into the trust? Okay? Your successor trustee does not have the authority to manage that account because it's not in the bucket. The only way we're gonna access that account upon your incapacity is either to one, open up a $8,000 conservatorship proceeding, $4,000 to $6,000 every single year after that, or the agent under this durable power of attorney can access that account and possibly manage it and get it into the trust for you. Okay, so that is what we call the durable power of attorney. Okay, now for those of you who may have already gotten your estate planning done in the past, most likely one of those documents you have is this durable power of attorney. Okay? However, in the past, I would always advise my clients, it is very important that you consistently update this power of attorney. I would say every 3 to 5 years. And the reason I would say that is because there was no guarantee that a third party would honor this power of attorney. They don't have to honor it if they don't want to honor it. If they don't honor it, we're going to open up the conservatorship proceeding. The number one reason why third parties will not honor the power of attorney is because they think it is too old. Okay, so the power of attorney is 10 years old. So they have an internal rule that if it's older than 3 or 5 years, we're just not going to accept it because they don't want to be liable. Maybe someone just held on to the copy of the power of attorney and you revoked it, and now they're trying to access the money out of your account. Okay? So that was a problem in the past. However, around 2000 and I would say 14 or 15, state of Hawaii passed a new statute that creates a statutory power of attorney. If you have this statutory power of attorney, the third parties are now required to honor your power of attorney. They cannot say they don't want to honor it because they think it's too old. Okay. So what I'm trying to tell you is this: for those of you who may have already gotten your estate planning documents done prior to maybe around 2015, chances are that power of attorney that you have is not a statutory power of attorney. It is a no-brainer. You have to upgrade to this statutory power of attorney. Okay. Next document is what we call the Advanced Healthcare Directive. It serves two purposes. First purpose, in the event you cannot effectively communicate your healthcare decisions, you can name agents and successor agents to make these healthcare decisions for you. These healthcare agents can make any healthcare decisions except for end-of-life decisions, because that is the other purpose of this document. Okay, so now what's happening is the doctors have determined you're in a permanent vegetative state. If you have absolutely no chance of living a meaningful life going forward, once this determination is made, your end-of-life decision will kick in. Main options are going to be number one, keep me alive by artificial means. So the machines are trying to keep you alive. Okay? Number two, just pull a plug, just let me go. I don't want to live like that. Okay? And those are your two most common options in most advanced healthcare directives out there. We do have a third option, which is the most popular option for my clients. And that option says, after X amount of days, and you get to decide how many days. If there is no improvement within those number of days, then pull the plug and let me go. Some clients will pick this number of days option because maybe you have family outside of this island. You want to give them an opportunity to fly and pay their last respects. Or maybe during the number of days, a miracle could happen. You might come out of it. You want to give yourself one last chance. Okay. The important thing to remember is this: that end of life issue is a very sensitive issue. If you don't make the decision yourself, essentially you're putting the burden on everybody else to make for you. And if they don't agree, that's when they might fight, because it is such a sensitive issue. So it's very important that you make this determination yourself. Okay? Finally, we have this document called the HIPAA authorization. So HIPAA is basically a federal act that says healthcare providers cannot release your healthcare information to anyone without your express authorization. The reason we have this HIPAA authorization is because everybody that you named in all the various capacities, so your successor trustees, personal representatives under your will, agents under your durable power of attorney and advanced healthcare directive, everybody's going to get access to your healthcare information just in case they need that information to do their position. Okay? So in a nutshell, that's kind of what estate planning is all about. These are the main estate planning documents. You need every single one of these documents. If you're missing any one of these documents, you essentially have a hole in your plan. Now, I do want to spend a little time on some updates, changes. First of all, there's this thing called an estate tax, okay, which is a tax on your privilege of transferring property at your death. Okay? However, the good news is everybody has this thing called an exemption amount, which means you can transfer up to that exemption amount completely estate tax free. Most people have nothing to worry about when it comes to this estate tax, because on the federal side, that exemption is like over $11 million. On the state side is over $6 million per person. Okay, so most people, we don't have to worry about the estate tax. Okay. I already talked about the statutory durable power of attorney. Again, if your power of attorney was created prior to or around 2015 or 14, chances are it is not a statutory power of attorney. you should definitely upgrade to that statutory power of attorney. Another thing I want to talk about is what we call tenants by the entirety, which is a form of property ownership that's only available to husband and wife. Okay. Now, the good thing about tenants by the entirety is that there is a creditor protection aspect associated with tenants by the entirety ownership, which basically says a creditor of one spouse cannot touch tenants by the entirety property. Okay. So for example, we have husband and wife, husband, and they own this property as tenants by the entirety. Husband is driving down the street, gets into a car accident. Someone died. Unfortunately, it was his fault. Now that person who died, their estate is going to come back, sue husband. It's going to take everything husband has. Okay. But they will not be able to touch the property husband owns with wife as tenants by the entirety because it's a creditor of just husband. So that's why tenants by the entirety is good. Okay. Now, remember, if you do your trust, think of your trust as a bucket. We're now going to have to get the bucket or the property into the bucket. We have to convey or fund the trust with that property. Okay? But remember, I told you, tenants by the entirety is a form of property ownership only available to husband and wife. Okay? So if you transfer the property that was tenants by the entirety into your trust, technically it is not owned by husband and wife anymore. So it's questionable whether or not you're still going to get this protection. Okay. So that was a very gray area in our law. Okay. However, again, I think around 2015, state of Hawaii passed a new statute to clarify this gray area. Okay. So what the statute says is this: if you own property as tenants by the entirety, and then you subsequently convey that property into the trust, you can and you will maintain the creditor protection aspect of tenants by the entirety as long as you cite to this statute 509-2 in the deed conveying the property into the trust. Okay? Now, the reason that's important is because if you have a trust already and you already put the property into the trust, but you did this conveyance prior to this statute, it is clear now you're not going to get the protection anymore because you could not have complied with the statute because the statute was not in existence at that time. Okay? So what you're going to have to do for those people who already put the property into the trust prior to the statute coming out, if you want to get the protection, you're going to have to do two deeds. You're going to have to take the property out of your trust, make it tenants by the entirety between you and your spouse, and then put the property right back in, but cite to 509-2. It's something to keep in mind. Okay? Also, a couple of things I would say that kind of set our estate planning group apart from a lot of most other estate planning firms is, after you die, when you leave things to your kids or whoever you're going to leave it to, a lot of trusts will just, kind of give it to them outright without any type of protection whatsoever. Okay. In my opinion, there's no real good reason to just give things outright at your death because, again, you don't know when you're going to die. You don't know what position the beneficiaries might be in, especially if it's your kids. You want to take the extra precaution to kind of protect it for them. Whereas if you're just leaving it to like a charity or just above your friends, they're lucky enough to get your thing, and maybe you don't need that creditor protection. Another thing is that disability panel. So remember, most trusts out there will say, doctor decides whether or not I'm incapacitated. And I told you there's a lot of issues with that because you can, I've litigated that issue before, and unfortunately you can get a doctor to say whatever you want the doctor to say. If your incapacity is at issue, that type of language actually could make it worse, okay? But what we do is we rely on a disability panel. You put the control in your hands today while you're alive and well. You handpick whoever you want, however many people you want to make that determination. And also that remarriage provisions, most trusts out there do not have that remarriage provisions that we spoke of. Okay. One last thing I do want to leave you with before I open up to questions. So one very common question I get whenever I do these seminars and webinars is someone always asks, Dean, everything you talked about, it sounds really good, sounds important, but at the same time, it sounds like, if you were ultra wealthy, then yeah, I can understand why that person would need to do their estate planning. Okay. However, in my situation, they say, we have a very modest estate. We don't have a lot of money. We own a house. We have a little money in the bank, and that's about it. right? Somebody in my situation that's very modest, do we have to do our estate planning? Okay? So what I always tell those people is actually, I think you got it completely opposite. Okay? Think about it this way. If you were ultra wealthy, okay, get all the money in the world, and you don't do your estate planning, okay, yes, you are going to leave a huge mess upon your incapacity and upon your death. However, there's a lot of money to clean this mess up. Okay, we're not going to miss that money that we have to spend to clean this mess up because you have so much money. Okay? Whereas, if you have a very modest estate, okay, upon your incapacity and upon your death, you're going to leave the same mess. But the difference is this: upon your incapacity, instead of your hard-earned assets being used for your care, a lot of it will get eaten up in that conservatorship proceeding. When you die, instead of your hard-earned assets going to whoever you wanted it to go to, a lot of it will get eaten up in that probate proceeding. And it might not even end up going to whoever you want it to go to. Okay? So in my opinion, it is actually more important for the modest person to get their estate planning done more than the ultra wealthy. Okay? With that, I'm going to leave it up to, or I'll open up to any questions that you guys might have.
Hey, Dean, thanks so much. I have a few questions I'm going to pose to you. First off, one question is, if I put my property into a trust for protection, is it difficult to sell that property, assuming I'm still alive?
Okay, so first of all, I want to clarify, just because you put something into a revocable living trust does not in any way give you creditor protection whatsoever. Okay, so I don't want you to think just because I put my bank account into the trust and now I'm going to get sued, that account is protected from my lawsuit. It is actually not. Okay, and the reason is because one of the benefits of this trust is you maintain a lot of control. Okay, you can change your trust whenever you want to. You can add things into the trust, take things out of the trust. What the law says is if you have a creditor, your creditor stands in your shoes. Okay, so if you can just dip in anytime you want to take things out, and now you're getting sued, they're going to be able to dip into your trust. It might be a little more difficult, but eventually they would be able to. Okay, now the way we could get creditor protection for your house, however, is you got to own it as tenants by the entirety first if you're married. And then if you put it into the trust, that will give you the protection on the house, not because we put it into the trust, which we're going to do, but because of the way you owned it. Okay? Now, the second part of the question is, if the house is in the trust and later on I decide to sell it, is it going to be more difficult to sell? And in my opinion, no, it's going to be same thing as if you left it in your individual name. The only difference is you're selling it from your trust in your capacity as the trustee. The only additional thing you probably will have to do is when you're going through the escrow process, you might have to provide a copy of your trust to the escrow office so that they can, make sure that you have the authority to sell this property. But it's not going to make it more difficult. It's not going to take longer. It's not going to be more expensive because the property is in the trust.
Thanks, Dean. So the question we have is the estate tax based on total value of the bucket?
It's not only the bucket, it's everything that you have. It could, because there's certain things you might not put into the bucket, like your retirement, or if you didn't put a bank account into the trust, it's not like it's only based on whatever you put into the trust bucket. It's everything that you own.
How does life insurance play in the equation? Should it be included in the bucket?
Yes, usually yes. Okay, so usually we would name your trust as the beneficiary of the life insurance policy. Okay, and I'll explain to you why. So a lot of times clients tell me, well, do I need a trust? I could just name somebody as the beneficiary, and because I have a beneficiary designation in place, it'll avoid the probate proceeding, which is true. Okay, however, a couple of things. If when you die, that life insurance pays out the death benefit to whoever this beneficiary is. If that beneficiary is a minor, the insurance company will not give the minor the money, okay? Because we're going to have to open up the conservatorship proceeding because the minor is deemed incapacitated due to the fact that he or she is a minor. Okay, so that's one problem. You don't want to name a minor a beneficiary for life insurance. Another problem is, let's say the beneficiary is not a minor, but let's say the beneficiary is 18, 19, 20 years old. That's what I call babu's beneficiary, right? So you die, life insurance pays out the death benefit to the 18-year-old. What is that 18-year-old going to do? Blow it, okay? Another problem is that's still an outright distribution. So the beneficiary is not 18 years old. The beneficiary is an adult, like 30, 40 years old, responsible adult. But unfortunately, he's going to go through a divorce or got into a car accident and now is getting sued. He got the death benefit. It's going to get taken away. Okay. Whereas if you name the trust as a beneficiary, when you die, death benefit will be paid out into the trust and the bucket will say what's going to happen. So he's going to say, okay, give it to my 2 kids in these sub-trusts. We can provide protection against anything going on in their lives. If they're minors, not a problem. If they're babu's beneficiary, you can name somebody in charge to provide them with that guidance. So it's much better to name the trust as the beneficiary instead of just naming people outright.
All right. Another question is, are there any issues / concerns with combining property in a LLC with a trust?
No, it's no concerns, but if your property is owned by an LLC, then when we create the trust bucket, what we need to put into the bucket is the LLC. So you need to assign your membership interest in the LLC into the trust so that if you are incapacitated, the successor trustee has authority to manage the LLC and could possibly sell the property or do whatever they need to do. Or when you die, same thing, we avoid the probate. Okay. So if the property is in an LLC, we got to get the LLC into the trust.
How will the manager of the trust be notified of my death or, I guess, incapacitation?
Okay, so usually the people that you would be naming as your successor trustee. So in a married couple situation, you would most likely name your spouse. And then if your spouse cannot, you would name some backups, like maybe your adult children, maybe your siblings or someone like that. Okay. So chances are these people that you name are going to know of your death whenever you die. Okay? So they're the first line people that's going to probably find out upon your death. Now, if they don't find out, eventually we're going to find out you died. Okay. So when you die, you're not paying your bills, your mortgage, we're going to get notice of foreclosure or all kind of things are going to happen. So we're going to know that someone's going to find out you died. And then after we find out you died, then we're going to know you had a trust because your property was owned by the trust, right? Your bank accounts are all owned by the trust. So we know you have this trust. And if we look at this trust, it's going to say who that successor trustee is going to be.
All right. That's the only other question I see right now. Are there any more questions from the audience? Great questions too. That's just awesome question, Alan. Is estate planning different for each state?
Yeah, actually, so for the most part, estate planning is very similar throughout all the states. Okay. However, there are some small differences. For example, you know that statutory durable power of attorney I told you about, that state specific. Okay. There are other states that have their own state specific durable power of attorney. Okay? So you would want to do your estate planning most likely where you are residing and or where you own any type of assets like real property. That's where you should be doing it. Okay. But at the same time, on that note, let's say you created a trust in Hawaii, okay, and you put all these properties, bank accounts, and then later on you move to California. Just because you move to California doesn't mean that trust is no good. That trust is still fine. Okay? But let's say 10 years later, when you want to make some type of change, that's when I would recommend you just go see a California attorney because you're living there now and they can kind of update the trust for you that you originally created in Hawaii. But at a minimum, that power of attorney, you should already update to the California state-specific power of attorney.
And Dean, if you have multiple properties in different states and you don't have a trust, how expensive is that process when you pass on?
Yeah, thanks for asking that. That's something I wanted to point out. Totally forgot to do that. But from my understanding is a lot of the attendees today are service members. And first of all, I want to thank everybody for your service. But I also understand that a lot of times, just because you're in the military, it forces you to move around from state to state. Okay, so you're in Hawaii, you buy a Hawaii property, and then because you're in the service, it requires you to go to another state, and then maybe you buy another property there. Okay, if you don't do your estate planning, then when you die, we're gonna have to open up probates in every single state that you own assets in. So it's just basically, you know, I told you the average cost of a probate in Hawaii might be $6,000 to $8,000. Okay. Now you have another property in New York. We're gonna have to open up another probate there, ancillary probate. It won't be as expensive because it's kind of piggybacking around that first probate, but it's still gonna be additional expenses and additional time, definitely.
That one question brought up the other one, folks. So can one trust hold houses from different states? So say you have your trust in Hawaii, but you own houses in California. Can you put those California houses into that trust that you made while you're in Hawaii?
Absolutely, yes.
All right, perfect. And then
yes.
All right, perfect. And then how often do you update your trust?
So for my clients, I always make the recommendation that, so first of all, there's no like rule that you have to update it every 3 or 5 years or anything like that, okay? The only time you really got to update your estate planning documents is if, one, there's a major change in the law. So this trust is not going to work the way we thought it was going to work. Or there's some advancements in the law, like that tenants by the entirety statute that recently came out about 5-6 years ago. Okay. But the good news is it's not common. It's not like every single year there's going to be some kind of major change that forces you to make changes to your trust. The more common reason you're going to make changes is because there is a change in your situation. Okay, so you got married, you got divorced, you got another child. Whoever you named as successor trustees, they all died, or you don't like them, or they're incapacitated. Okay, so these are changes in your situation, which will prompt making adjustments or maintaining your estate planning documents. Now, what I recommend is for my clients, I always tell them every 4 to 5 years, just give me a call. And if you give me a call, what I'm going to do is over the phone, I'm just going to recap or summarize exactly what your estate planning documents say. Okay, these are your successor trustees. These are the people on your disability panel. These are your beneficiaries. This is the people in charge, you know, and if they tell me after that meeting, oh yeah, that's still what I want, then I tell them, okay, call me back in another 4 to 5 years. But if they tell me, oh no, these guys died, or I don't want them anymore, or I want to change this or that, then we'll set up a meeting to discuss what those changes might be.
All right, and then questions. These are great questions. I thank you all for asking them. On average, how much does it cost to set up a trust?
Okay, so the cost for an estate planning, not just the trust, because remember I told you, you need all those documents. If you're missing anyone, you have a hole in your plan. So for a complete estate plan, the cost will depend on 2 factors. Number one, whether you are single or married, okay, and the level of planning. Okay, so I can give you a range. Okay, so for a single, just basic plan, when you die, we just give things outright. Okay, that type of plan will cost around $1,700. Okay? For a couple, more advanced planning, when you guys die, we want to create these mini buckets or sub-trusts to provide the protection and guidance for your kids and remarriage provisions. That type of planning will probably be around $3,700. Okay? So it's going to be within that range. So again, it just kind of depends. And what I do is, when I meet with clients, it's up to the client. My job is to educate them. And then after I educate them, they decide, number one, whether or not they want to do this. If they want to do it, they can make the decision as to which level of planning is appropriate for their needs. And they will make informed decisions as to how they want to plan their estate.
And then on to that is, what is the first step to set up my estate planning?
The first step is to give me a call to set up a meeting so that we can look at your specific situation. I can give you an overview of, or answer any additional questions that you may have with regards to this webinar that you saw or your specific situation, and then we can go from there. So I popped up my number and my email address there.
And really your first step, you took your first step today, and that's to educate yourself. And Dean, I'm glad that you talked about the first thing you do is educate. This is obviously it's a big decision in someone's life to protect their assets. It's a decision that, you know, nobody likes to talk about. Well, what do I do? What happens if I pass? What happens if my spouse and I pass? Right? Nobody really sits down and talks about that, but that's that tough discussion that you have to have with your spouse, and then certainly with somebody who can help protect your assets. So thanks so much, Dean. And we got 5 minutes left. I understand it's a Saturday. We got a lot of things going on, but if there are any more questions, please don't hesitate. This is your time.
Yeah. May I add one thing? So I know that I gave you a lot of information in a very short period of time. Okay, I acknowledge that. Okay, however, I don't want anybody to feel overwhelmed. Okay, and the reason is because the goal of this webinar was not to make you an estate planning expert. Okay, the goal was to just kind of open your eyes so you have a general understanding of what's going to happen if you don't do any type of planning. So I think everybody got probates, conservatorships, generally bad things. Okay, which in turn makes you understand that, okay, that's why we need to do estate planning. And you have an idea of what estate planning is. It's a compilation of these various documents, and you have a general understanding of what each document kind of does. Okay, as long as you got that, I think we accomplished the goal of this webinar, was just to give you this basic understanding. Okay, one more thing I want to let everybody know, again, thank you, Larry and Align Mortgage, for putting on this seminar. This is just an added value that Align Mortgage provides to all of their clients. And I think the reason why they're doing this is because they know that you guys worked very hard for everything you have. They assisted you with purchasing probably your biggest asset, the property. But they also understand that if you don't do your estate planning, everything that you work so hard for can kind of fall apart if it's not wrapped up in a legal shell, so to speak. So Larry asked me to come on, so at least I can explain these things to you, and now you can make your own informed decisions this time. So again, thank you, Larry and Align Mortgage and this whole crew.